Be ready. Start. On the pleadings and material made available to the High Court at the hearing held on a short notice, we have no reason to doubt the statement made by the Election Commission and contained in its impugned notification that the Election Commission had carefully considered the matter and decided in the light of the prevailing situation in the state and in the interest of free and fair election and also for safety and security of electors and with a view to preventing intimidation and victimization of electors in the state, a case for direction attracting applicability of Rule 59A for counting of votes in the constituencies of the state excepting the two constituencies where electronic voting machines were employed. It was admitted by the Electricity Board that apart from unskilled laborers, the benefit of the Wage Board recommendations was extended to all other employees of ex-licensee company, taking into account their past services from 1/4/1969 till 6/2/1975. There might be some rationale in denying such benefits to those who were getting higher pay. The action of the Electricity Board was utterly arbitrary. Electricity Board, being a government instrumentality, cannot act in an arbitrary manner, denying the benefit to those who deserve it most and extending the benefits to those who deserve it less than the persons who have been denied the benefit is clearly arbitrary. The main defense of the Electricity Board was that prior to 1975 the employees concerned were not its employees, hence for the said period it owed no obligation to them. The stand was clearly against the provisions of the Ordinance of 1975 and Act of 1975. By virtue of Section 6A 3A, the required undertakings vested in the Electricity Board free from any doubt, mortgage or similar obligation of the licensee attaching to the undertakings. These words do not cover the obligations in respect of employees. Firstly, the word obligation is qualified by word similar and similar obligation succeeds debt and mortgage. It is therefore clear that obligation must have some relation with obligation arising out of debt or mortgage. Secondly, debt, mortgage or similar obligation which are not binding upon the Electricity Board are only those which were attached to the undertakings. The obligation in respect of employees and their wages is not covered by the said clause. In respect of other obligations, the provision was made under Clause B of the subsection by virtue of which obligation of the licensee stood transferred to the board. The two clauses read together clearly indicate that all obligations of the licensee except obligation attached to the undertaking stood transferred to the Electricity Board. The employees of the licensees became employees of the board after taking over on the same terms and conditions and with the same right as to pension, gratuity and other matters. Secondly, the deceased was employed in a limited company. It was necessary for the claimants to establish what was the monthly income and what was the dependency on the basis of which the compensation could be adjudged as payable.